Here's something nobody tells you when you pay off your mortgage. The day you make that final payment, the day you own your home outright, free and clear, no bank involved, that's supposed to be the finish line. That's supposed to be the moment decades of sacrifice finally pay off. But in 2026, that paid off home might be the most dangerous asset your family owns, not because of property taxes, not because of inflation, not because of some market crash, because of a government program most Americans have never heard of. A program that has been quietly, legally, systematically waiting in the background since 1993. A program that doesn't touch your home while you're alive. It waits. It watches. And the moment your parents die, the moment the funeral is over and probate opens, it sends a bill. Let me give you the real picture. Imagine your father spent 34 years working a physical job. He scrimped. He saved. He paid off the family home in cash. That house is worth $400. Zero today. It's the only real asset he ever accumulated. His entire legacy is sitting in that house. He develops dementia in his late 70s. He goes into memory care. The social worker at the facility sits your family down and says, "Don't worry, he qualifies for Medicaid. The care is covered." And his house? His house is safe. 3 years later, he passes away. And 2 weeks after the funeral, a certified letter arrives from the state attorney general's office. The state isn't offering condolences. The state is filing a creditor claim against your father's estate, $340,000, for the Medicaid-funded nursing home care, collateralized against the house you thought was safe, the house that was never safe. Welcome to AJ Retires Tips. Today we're going deep on the Medicaid Estate Recovery Program, what it is, how it works, why almost no one warns families about it until it's too late, and what you can actually do right now to protect your family's home before the window closes. Stay with me through this entire video because we're covering 5 specific legal strategies that can shield a paid-off home from this program entirely. Not vague suggestions, actual legal tools with names, mechanics, and real numbers. By the end, you'll know exactly what to ask an elder law attorney and exactly what questions to bring to the table. And before we get into the mechanics, drop a comment right now. Tell me your state. Tell me if anyone in your family has ever been told by a hospital social worker or nursing home admissions coordinator that the house is safe. Because that phrase has been deployed against American families in virtually every state in this country. I want to hear your story. Let's start with the foundational misunderstanding that sets this entire trap in motion. Most people believe Medicare covers nursing home care, and it's a completely reasonable belief. You paid into Medicare for your entire working life. Every paycheck, every year, a line item came out labeled FICA. A portion of that went directly into the hospital insurance trust fund. You held up your end of the deal for decades. So when you turn 65, sign up for Medicare, maybe add a supplement policy, you naturally assume the full spectrum of care is covered. Doctor visits, hospitalizations, and yes, nursing home care if it ever comes to that. Here's where the system quietly moves the goalposts. Medicare covers something called skilled nursing care. That's a very specific, very narrow category. It means you had a qualifying hospital stay of at least 3 nights. You transferred to a skilled nursing facility within 30 days, and you require active clinical rehabilitation, physical therapy after surgery, IV antibiotics, wound management by a licensed nurse. Under those conditions, Medicare covers the first 20 days at 100%. Days 21 through 100, you share the cost, roughly $200 per day out of pocket in 2026. And on day 101, coverage ends completely. That's the hard ceiling. Day 101. After that, you're on your own. Now here's the critical gap. The care that most elderly Americans actually need isn't skilled nursing care. It's what the industry calls custodial care. Help bathing, help eating, help managing medications. Help for someone with dementia who can no longer safely be left alone. Medicare pays $0 for custodial care. Not a dollar, not a day. And custodial care is exactly what the majority of nursing home residents need long term. In 2026, custodial nursing home care runs between $10, $0 and $12,000 per month in most major markets. Memory care units are closer to $13,000. In high cost of living metros, New York, Boston, the Bay Area, Seattle, you're looking at $15,000 to $17,000 monthly. Run the math. At $12,000 a month, that's $144,000 per year. The median retirement savings for an American reaching 65 in 2026 is roughly $280,000 total. 2 years of custodial care wipes that out entirely. And when the savings are gone, families turn to the one government program that actually does cover long-term custodial care, Medicaid. Unlike Medicare, Medicaid will pay for unlimited custodial nursing home care. But Medicaid was designed in 1965 as a poverty program. To qualify, you have to be nearly broke. Most states in 2026 cap countable assets at $2,000 for a single applicant, so the family spends down everything. The savings, the investments, the retirement accounts, all of it goes. And then they apply for Medicaid. And the social worker smiles and says, "The house is safe. She has the legal intent to return home. The house is exempt from the asset test." That statement is technically accurate, while the Medicaid recipient is alive. The moment they die, everything changes. The Medicaid Estate Recovery Program isn't a loophole. It isn't a bureaucratic gray area. It is mandatory federal law. In 1993, the Omnibus Budget Reconciliation Act required every state in the country to operate an estate recovery program. If a state wants to receive federal Medicaid matching funds, and every state does, it must run MERP. There's no opting out. Here's how the mechanics work. When a Medicaid recipient over age 55 dies, the state Medicaid agency files a creditor claim against that person's estate during probate. The claim equals the total amount the state spent on their long-term care from age 55 forward: nursing home costs, prescriptions, hospital services, and related expenses. In a typical 2026 case, 3 years of nursing home care generates a Medicaid bill somewhere between $320,000 and $450,000. That bill lands in probate court and in many states sits at the very top of the creditor priority list. It outranks credit card debt. It outranks most other medical bills. The personal representative of the estate, usually the eldest child, has a legal duty to satisfy that claim before a single dollar passes to the heirs. If there's cash in the estate, cash goes first. But there usually isn't much cash because the person spent down to qualify for Medicaid in the first place. That leaves the house. And some states don't even wait for death to get involved. About a third of states pre-file what's called a TEFRA lien, named after the Tax Equity and Fiscal Responsibility Act, directly against the home's title while the Medicaid recipient is still living. The lien sits silently at the county recorder's office. The family doesn't discover it until they try to sell, refinance, or transfer the property. Now here's where it gets complicated, and this matters depending on where your family lives. Not every state runs MERP the same way. Take Florida. Florida's Constitution provides one of the strongest homestead protections in the country. A creditor generally cannot force the sale of a Florida homestead. The state Medicaid agency can file a claim, but enforcing it against a home that passes to a qualified heir under Florida's homestead descent rules is extremely difficult. Florida is, relative to most states, protective for families in this situation. Now look at Ohio. Ohio uses what's called an expanded estate recovery definition. Most states can only recover from assets that pass through probate. Ohio goes further. Joint tenancy transfers, certain living trust structures, transfer on death deeds. Ohio's statute specifically captures these under its expanded recovery definition. It's one of the most aggressive MERP states in the country. Then look at California, which reformed its program in 2017. California now only recovers from probate assets, only goes after care received after age 55, and excludes certain categories entirely. A California family with a home properly held in a funded living trust may pass that property to heirs with no MERP recovery at all. 3 states. 3 completely different outcomes for an identical family situation. This is why the state you live in and the state your parents live in isn't a minor detail in retirement planning. It's the central variable. So the natural reaction to all of this is, fine. I'll just transfer the house to my kids before I need nursing home care. Problem solved. The federal government anticipated that move. That's why the look-back period exists. Under the Deficit Reduction Act of 2005, when you apply for long-term care Medicaid, the state reviews every financial transaction you made in the prior 60 months. 5 years of bank statements, deed transfers, gifts, asset sales, all of it. If they find any transfer where you gave something away or sold it for less than fair market value, they impose a penalty period. The calculation: take the value of what you transferred and divide it by the average monthly nursing home cost in your state. The result is the number of months you're disqualified from Medicaid. Here's what that looks like in practice. You're 76 years old. You transfer your $360,000 home to your daughter in March 2026. 5 months later, you have a stroke and need nursing home care. You apply for Medicaid. The caseworker finds the deed transfer. Ohio's average monthly nursing home cost is around $8,500. $360,000 divided by $8. $500 equals roughly 42 months of disqualification. 3.5 years during which you need $12,000 a month of care. You don't have the money. The nursing home may refuse to admit you. Your daughter, who now owns the house, becomes the default solution, draining her own savings, disrupting her career, straining her household. That's the look-back trap. That's why last-minute planning fails. The look-back window is 5 full years. The legal architecture has to be built while you are healthy, while you're still driving, still living independently, still years away from needing care. The bitter reality of this system is that the healthier you are when you plan, the less it costs and the more protection you get. The sicker you get, the fewer options remain. Let's talk about what actually works. There are 5 well-established legal strategies for protecting a home from MERP. Each one has specific conditions, state-by-state variations, and has to be implemented correctly to hold up. This is not a substitute for working with a qualified elder law attorney, but this is exactly what you need to know before you walk into that office. Strategy 1. The Medicaid Asset Protection Trust. This is the most powerful tool available to the middle-class family for MERP defense. A Medicaid Asset Protection Trust, MAPT, is an irrevocable trust. You transfer your home into it. You lose legal ownership of the property, and that's precisely why it works. Assets you don't legally own can't be counted toward Medicaid eligibility, can't be recovered by the state after your death, and never pass through probate. You can still live in the home. You retain what's called a retained life estate or a reserved occupancy provision. You still pay property taxes. From the outside, nothing changes, but legally, the home is held by the trust. Once 5 years pass from the date of the transfer, clearing the look-back window, the home is completely protected. Real numbers. A properly drafted map typically costs between $3,000 and $6,000 in attorney fees. For a home worth $400,000, that's a relatively small upfront cost to protect the full asset. The critical requirement: you need 5 years of lead time. The trust must be funded, and the look-back must expire before a Medicaid application is necessary. Strategy 2. The caregiver child exception. This is one of the most overlooked provisions in federal Medicaid law, and for the right family situation, it's extraordinarily powerful. Under federal statute, if an adult child moves into the parent's home, lives there for at least 2 years immediately before the parent enters a nursing facility, and provides care during that period that allowed the parent to remain at home rather than enter institutional care sooner, the parent can transfer the home to that child with 0 look-back penalty. The transfer is fully exempt. The 5-year clock doesn't apply at all. This requires documentation, a written caregiving log, medical records showing the parent would have needed facility care without the child's help, and proper legal structuring of the transfer. Done correctly, it's one of the cleanest exits from MERP available. Strategy 3. The Ladybird deed available in a limited number of states: Florida, Texas, Michigan, and a few others. The Enhanced Life Estate Deed, commonly called a Ladybird deed, lets you retain full control of your home during your lifetime. You can sell it, mortgage it, change your mind completely. At your death, the property automatically transfers to the named beneficiary without going through probate. Because it never enters probate, in states that recognize this instrument, it effectively bypasses MERP recovery entirely. In Florida, a Ladybird deed can often be drafted for under $600. For MERP recovery purposes specifically, it's one of the most cost-effective tools available in the states that allow it. Important caveat: a Ladybird deed doesn't help with the Medicaid asset eligibility test, only the recovery piece. For full protection, it's often used alongside other strategies. Strategy 4. The Community Spouse Resource Allowance. When one spouse needs nursing home care and the other doesn't, federal law protects the healthy spouse from being completely impoverished. In 2026, the federal maximum community spouse resource allowance is approximately $157,000 in countable assets, plus the home, plus a vehicle. In some states, including New York and Florida, there's an additional technique called spousal refusal, where the community spouse formally declines to contribute to the institutionalized spouse's care, forcing Medicaid to evaluate eligibility based only on the nursing home spouse's individual assets. The state may pursue recovery later, but immediate Medicaid qualification is preserved. This requires an elder law attorney to execute correctly, but in the right situation, it's a legitimate and well-established strategy. Strategy 5. Long-term care insurance with a partnership rider. Every state now operates some version of a long-term care insurance partnership program. If you purchase a qualified partnership policy, every dollar the policy pays out in benefits creates a corresponding dollar of asset protection. Medicaid and critically, those protected assets are also shielded from MERP recovery. A $200 zero-zane partnership policy that pays out fully means you can keep $200,000 in countable assets and still qualify for Medicaid when the policy is exhausted. Premium for a healthy 60-year-old in 2026 runs roughly $3,000 to $5,000 per year. It's a real cost, but it's a real hedge against a six-figure MERP claim down the road. Here's something worth saying clearly. The federal estate tax exemption right now sits at $15 million per individual. The financial media talks about estate taxes constantly. Politicians debate it. Wealth advisors build entire practices around it. But the estate tax applies to a tiny fraction of American families. MERP applies to anyone who used Medicaid for long-term care after age 55. Period. It doesn't matter if your estate is worth $15 million or $200,000. The mechanics are identical. The $6,000 senior bonus deduction that made news in 2026's tax code saves maybe $1,500 on your federal return. That's 231 years of senior bonus deductions, wiped out in a single MERP filing on a $347,000 claim. And here's the quiet irony that makes this even harder to take. Federal tax law provides a step up in basis at death. When your parents die, your inherited assets are valued at current fair market value, not the original purchase price. A house bought for $68, zero in 1979 gets stepped up to $400,000 today. You inherit it and sell it with no capital gains tax. The IRS gave you something genuinely valuable. And then the state reaches in and takes $347,000 of that $400,000 in a MERP filing. The federal government gives, the state government takes. And the only people who understand the choreography of that handoff are the elder law attorneys and the families who learned about it the hard way. I want to hear from you in the comments. Tell me your state. Tell me your age bracket. Tell me whether anyone in your family has ever been told by a hospital social worker or nursing home admissions coordinator that the house was safe. And tell me which of the 5 strategies you're going to bring to an elder law attorney first. Because your comment is the next family's warning. Some people watching this are thinking, this can't be right. If this were really happening on this scale, it would be bigger news. Here's why it isn't. MERP claims hit families during probate, months after a death, when the family is grieving, exhausted, and not looking for a fight. Most families don't have the legal knowledge to challenge the claim. Most families don't even realize a challenge is possible in some circumstances. They pay, they sell the house, they move on. There's no single political constituency organized around fighting this. The families it affects are scattered across every state, every income bracket. The program has been embedded in federal law since 1993. It's not new policy. It's not a news story. It's just the system working exactly as it was designed to work, quietly, after the funeral. So here's what I want you to do tonight, not next week. Tonight, step 1, pull out the deed on every piece of real estate you or your spouse own. Look at exactly how title is held. Sole ownership, joint tenancy, living trust, know what you have. Step 2, list every asset you own outside of qualified retirement accounts. Homes, savings accounts, brokerage accounts, CDs, life insurance, cash value. Get a real number. Step 3, find a board-certified elder law attorney in your state. Not a generalist, not someone who handles elder law occasionally. The National Academy of Elder Law Attorneys maintains a public directory. Use it. Step 4, schedule the consultation. The fee runs between $200 and $750. It is the highest return conversation you will have in 2026. Step 5, start the 5-year clock. Whatever strategy your attorney recommends, mapped, ladybird deed, partnership policy, caregiver child documentation, get it in place now. Because every day you wait, the look-back window slides further back and the protection arrives later. The 5-year clock is either running for you or against you right now. There's no neutral. A paid-off home is supposed to represent a lifetime of work passed down to the next generation. MERP was built to intercept that transfer at the exact moment of maximum vulnerability, after death during probate when the family has no leverage. You can't stop the program from existing, but you can make sure your family's home is never in its path. That's what this channel is for. I'm AJ. Subscribe, hit the bell, and I'll see you in the next one.